I'm Jay Brown. I'm board certified in civil trial law and also personal injury trial law. Mr. House, nice to meet you. Like Mr. House in his office, I don't just sit in the library. I go in the courthouses, state and federal, try cases. Honored and privileged to represent CCA, many different lawsuits. I can count them. It's been well over 100 across the state. With the recent changes that the Texas Supreme Court has made, it is extremely difficult for someone to successfully sue a county in Texas in this arena. As Your Honor knows, the county has what's called governmental immunity. That encompasses two things. It encompasses immunity from liability and immunity from suit. Okay, immunity from liability is a solid protection. Immunity from suit even deprives the court of jurisdiction. I represent, along with counties that are sued in cases, and they get out of the case, usually about like that, and CCA is left in the case, if there is a case. So whatever I said, wrong or right, cannot make the county liable. You can't change the laws of Texas.
But ICE was basically saying, county, there's a monitoring system not working and you should have had it fixed. And that's concerning because we're not, that's CCA's responsibility to fix that, if it's a mechanical or whatever it was. And so, unfortunately, we're caught with a bad situation, and I'm picking one little spot out of there to bring up because of this. And I think Damon knows we've had a lot of discussion on that. And you're saying, what you're debating with us is we would not be responsible, regardless of what ICE is saying and so forth, for being sure that a laser system or a monitoring system or an air conditioning system or whatever else in that building, we're not responsible.
I would want to have two questions for you. Is it county-owned property?
Well, you already answered that.
No. Was a county actor involved in the use of the property? Did a sheriff fire a gun? Did a sheriff use some other equipment? Did a sheriff use a baton? Did a sheriff use a phone base? No. Then the answer to your question, Your Honor, is no. No liability. And I would welcome the chance to show you that with cases and statutes. Just out of personal interest, I'd like the opportunity to meet you in the county attorney's office so that you're at least confident in my abilities if I'm called on. I'd be happy to respond to any questions, legal or practical, now or in executive session or at any other time.
I'm not sure we can legally have you in executive session. Okay. Are y'all willing to spend a few days here looking at briefs and so forth that he talked about? Is that time that you think would be well spent?
Yes, Your Honor.
Well, with that, then I'm going to ask that you do that and that you let him supply us with the information we need, and that your office please look at those and be prepared to give us an answer back in a reasonable period of time. Time is of essence. We don't need everybody in this courtroom every week looking for what we're going to do. But at the same time, I want to give our attorneys and you a chance to give us the best thought out answers that we can get so we can make the right decision.
I think it would be helpful to have at least a couple of weeks to make sure. I want to make sure that I respond to every question the county has. And I want to give the county time where I provide information that they can ask questions and then ask more questions.
Well, I'll put it back on the agenda at when the county attorney's office requests me to put it back on the agenda. So I have a motion that we table items 14 through 17. That's by Geddes, and a second by Colby. That motion is undebatable, and all those in favor, please raise your right hand. Motion carries 5-0. Thank you very much.
Thank you.